Hi, I'm attorney Gregory Dell, joined today by attorney Rachel Alters, and we're going to talk about long-term disability insurance claims for insurance claim adjusters. And Rachel, we've represented tons of insurance claims adjusters, but every time we get a claim for an insurance claims adjuster, we kind of feel like it's that the disability insurance companies have no mercy.
Right.
Because often the insurance claims adjusters that we represented have long-term or short-term disability coverage with the same company that they're working for.
Right.
And so it's you'd think there'd be a little bit of a preferential treatment or some kind of like a little bit more leniency or something to say, look, yeah, you work for us, we know the duties of your job inside out, and if you can't do it, that it would be a little bit easier approval process. But it seems to be that they, as I say, the disability insurance companies are equal opportunity screwers, meaning they'll screw over even their own kind. No matter what, it doesn't matter. So when you're representing an insurance claims adjuster and they contact you, whether they're applying or they're on claim already or they're denied, what's the first thing that you need to get from them in order to understand how you can help them?
Well, obviously, when I speak to the insurance adjuster, they're going to tell me, oh, yeah, I work for MetLife or Prudential or whatever it may be, and I'm the one who makes the decision on whether it's long-term disability claims or if it's auto or whatever they're doing. I need to find out what's keeping them from working. So what I first ask them is, well, what's your disability? What's going on? Why can't you act as an adjuster anymore? Normally, an adjuster is a sedentary job where they sit at a desk 40 hours a week, they make phone calls, they're on the computer a lot. It's mainly a sedentary job. So I ask them what's going on, and then do they have medical support to support their inability to work? Because if they're an insurance adjuster who works on disability claims, they know very well what they need, but they're put in a vulnerable position where now they're the ones who have been denied, and they're the ones who are upset, and sometimes they're not thinking straight, and they do need a lawyer to help them through the process.
All right, and so how different is the policy language and how important is the policy language when an insurance claims adjuster first contacts you?
Well, the policy language is going to be the same for the insurance adjuster and the claimant, whoever has that policy. It's going to be for the first 24 months of their disability. Can they perform their own occupation? Are they able to do the material substantial duties of their own occupation as it's defined in the national economy? So it's going to be, can they do the sedentary job sitting at a desk, at a computer, 8 hours a day, 40 hours a week, and with some sort of reasonable continuity, or are they not able to do that? And after 24 months, it usually switches to, can you do any gainful occupation? So that's really important to go over with the claimant, who is the adjuster, and find out from them how their job is defined in the national economy, because it's not going to be how they do their job every day at their insurance carrier in their office. It's going to be how it's defined in the national economy, and that's where it becomes a little difficult.
And when you talk about insurance claims adjusters, obviously, we do disability insurance claims, but it could be life insurance, long-term care, health insurance, homeowners, auto.
Right.
And you mentioned earlier that it could be sedentary, as a sedentary occupation, but for someone who does homeowners, it could be obviously far more, not just sedentary because they got to climb in attics or climb in buildings or
Sure.
look at destructive property or whatever, very physical type things, lift things to look. Obviously, disability insurance and people in offices don't have to do that. But when you talk about this national economy definition, is the person who is the property damage appraiser or auto appraiser who has to do physical type things going to have their job evaluated as a medium to heavy duty type job that requires a lot of lifting, bending, climbing ladders, in the same manner as the person who's disability insurance who's primarily in their office? So
no, it should be evaluated in a different way, but it depends on how the insurance carrier is going to look at the job title. So if it's just insurance adjuster and they're not willing to look at the specifics of the type of insurance adjuster, right, then it becomes more of a job for us to get them to look at the specifics of, are they climbing ladders, are they lifting heavy objects,
right,
versus are they sitting at a desk? Because if you just type in insurance adjuster in the Department of Occupational Titles, it's not going to say somebody who's climbing up ladders.
Right.
So it's up to us to bring it to the insurance carrier's attention that this is not the typical insurance adjuster job where they're sitting in an office all day reading through medical records. So that's where we come in to make the difference, obvious to the carrier.
And in terms of most of the time, it's going to come down to a sedentary type job. What type of medical evidence is going to be expected to be presented to support a sedentary type occupation like, the typical definition for insurance adjuster?
Right. And it depends what the insurance adjuster's disability is, what their medical issue is. If they have a physical issue with their back, they're going to want to see MRIs, they're going to want to see x-rays, objective proof that they have a back issue, that whether that affects their arms and their legs as well. It's all going to need to be documented in the medical records so that the insurance carrier can look through the records and say, okay, I see that this problem occurs. I see that this is a real issue and that they're receiving treatment. So they want to see that you're treating with a proper specialist, that specialist is documenting what your restrictions and limitations are. It's very important. But if you have an issue such as maybe MS, where maybe it's more cognitive, they're going to want to see documentation of why you can't focus, why you can't concentrate. There's a lot of different, depending on the type of illness they have, we're looking for different things. So if, like I said, if it's physical, if it's a back or a neck issue, we want to see that an MRI was done, that maybe they're having injections, that there's possibly, some surgery recommended. If it's something more cognitive, then we're going to look more towards maybe a neuropsych evaluation or what a neurologist is documenting about their ability to focus and concentrate.
And then you mentioned earlier when we started this video about how there's usually this change of definition from their own occupation to any occupation. Right. But if you're starting with an own occupation that's typically a sedentary type job, which means a job where you're expected to sit for more than 6 hours a day, and then you're switching to an any occupation job, which if you just go by job classification is going to be sedentary as well.
Right.
Why do we still see so many denials at that change of definition when you're going from sedentary to sedentary?
Right. You would think it would be okay if you can't do your sedentary job for 24 months, you still can't do your sedentary job for the next 10 years if you're still sick. What they do is a lot of times in these policies, there's also a change in the definition as it refers to the amount of income that you can earn. So a lot of the policies will say, well, now for the first 24 months, it's can you earn 80% of your pre-disability income? Then it'll switch to can you earn 60%? And if you can earn up to 60% and do a sedentary job, then we think that you're fine and you can go back to work. And they'll find 3 or 4 jobs, in your area that they think that you can handle, and it'll pay you 60%. And then in their minds, you could go back to work. So when that changes, then they say, okay, now we have a reason. Or, they'll follow you with surveillance after 24 months and see that you can do things, what they claim is, you could sit for long periods. We saw you driving in a car for an hour. Right. So now we think that you've actually improved after the 24 months. So not only can you earn up to 60%, but we see, reasons that we believe, you could sit at a desk, do a job 40 hours a week and be fine, when it's usually not the case.
So this 24-month mark is kind of like an impetus for them to say, we're going to reevaluate the claim, even though they can do it at any given time. But when they do that, it's usually at another insurance claims adjuster who didn't have the claim initially. It went to someone new. Now they do a new medical review. Right. And the insurance claims adjusters who handle these disability claims almost always rubber stamp whatever their hired, either in-house doctor, outside doctor, or IME doctor says, regardless of how many doctors the claimant has supporting them. So then they just adopt that in that situation, which becomes a problem for the claimant. That happens because they reevaluated it at 24 months. So, when the claimants get on claim though, and they've been approved, is that something that's going to continue forever, or how often is the claim being reevaluated? Right,
and that's a good question, because oftentimes my clients will say, well, my doctor says my disability is permanent. I'm never going to get better. This is going to be it. So I should be insured and paid till I'm 65. Well, unfortunately, that doesn't happen. The insurance carriers are evaluating the claims constantly. So normally, I would say at the beginning of a claim, every 6 months, they're going to want updated claim forms. They're going to want updated medical records. So we always make sure that when we're handling the claim, we're getting all the updated records, reviewing them, making sure that they look in such a way that the claim will continue to get paid. And then as the claim gets older, once you get past the 24-month ONOC period into the any gainful occupation period, oftentimes they will slow down a little bit, but it depends, like you said, they bring on new adjusters all the time.
Right.
And when they do that, then they're, gung-ho, want to deny the claim. They go through everything and they look for reasons to deny. So we never let our guard down. So we're always making sure that our claimants or our clients are treating on an ongoing basis, regular, every couple months, at the most 3 months between visits, so that we can't run into the situation where the carrier says, okay, it's been 6 months or it's been a year, give me all the updated medical records, and there aren't any. That's the worst case scenario. And when that happens, they're like, oh, well, if you're not treating, obviously you're fine, we're gonna cut the claim off. So it's really important that the treatment's ongoing, that we are on top of the medical records, and it can happen every 6 months, possibly once a year. For short-term claims, it can be every, once a week, they want updated records.
So we talked about a lot of the things to protect the benefits when you're applying or if you're on claim, and really comes down to strong medical documentation, never letting your guard down, detailed claimant forms and things like that. But for the claimant who's been denied, and most of these insurance claims adjusters have group employer provided policies, they're going to be subject to the ERISA regulations, because a lot of the insurance claims agents rarely buy their own disability policy on their own. And so ERISA is going to govern, which, can you just explain briefly about what it means of having to do an appeal, and then what the litigation process would be like if the appeal isn't won?
Sure. ERISA is a federal law, and it's, it was enacted in 1974, and essentially what it does, it really protects the insurance carriers, the employers, more so than it protects the claimants. But what it is, it's a specific set of rules where you have to follow when you file a claim, the claim gets denied, and most insurance carriers require at least one administrative appeal before you can sue. A lot of carriers require 2 before you can sue. I don't need to name them, but some of them have a mandatory appeal process,
Right.
and then there's a voluntary appeal process. So no matter what, you have to do at least one appeal. The administrative appeal is essentially the trial, because once you get to trial, all the judge will look at is what you put into the appeal and what's already in that administrative record. So it's really important to put everything you can into this appeal, especially if you only have 1. If you have 2, oftentimes you can, add things in the second appeal,
Right.
if you forgot to put them in the first, or if things came up such as getting approved for Social Security, another medical issue was diagnosed, that can go into a second appeal. But unfortunately, after you submit the first appeal, if you're only allowed 1, anything that comes up after that first appeal is done and a decision is made doesn't get seen by a judge. So like I said, it's really important to make sure you have an attorney that knows what they're doing. They're specialized in doing ERISA appeals. Everything gets put into the appeal, all the medicals, every test you can think of that could help get the person approved. And once that appeal is decided on, if it's not overturned, meaning that the insurance company doesn't approve them, the next step is that you have to file a complaint or a lawsuit in federal court.
Right.
And that's in front of a judge, and that is, there's no jury, and the judge is deciding whether the insurance company was arbitrary and capricious in the denial of the claim, which in layman's terms is, did they have a reasonable basis to deny the claim or not? If they say that there was a reasonable basis, which could be just that they had a medical doctor review the records and write an opinion that was completely opposite of the treating physicians, stating that, this claimant is not disabled. We disagree with the treating doctors who say that the claimant is, disabled and not able to work. We think the opposite. We think that they can work a sedentary job, sitting at a desk 40 hours a week, and absolutely, that is our opinion. And the judge can look at that and say, well, that's reasonable, and the claimant loses. So unfortunately, that's what we face, and we explain that to our claimants, that it's a very difficult hurdle to get a judge to say that the insurance carrier was arbitrary and capricious. Now, it does happen, and if we do win that case, then we can win the back benefits that they're owed, and then what the judge will do is remand. That means sending the case back to the insurance company for another review to decide if the claimant is still disabled ongoing and deserves to get paid monthly. So it's a long process, and if it doesn't happen, if we don't actually go to trial, most of the time we do end up settling those lawsuits for a lump sum settlement, and then the claimant walks away and doesn't have anything to do with the insurance company anymore. I mean, there's obviously much more detail involved, but that's just kind of in a nutshell.
And we have other videos where we've talked about ERISA litigation and ERISA appeals that are quite extensive and provide information for that. But Rachel, the important thing is for an insurance claim agent who has a long-term disability insurance claim, we encourage them to reach out to us for a free initial consultation. No matter where you live in the country, whether it's Rachel, myself, or any of our lawyers, we're available to assist you. It's quite simple to get in touch with us. You either call us at the number below on your screen, or you submit the free consultation email request on our website. We will immediately contact you and schedule an appointment to discuss how we can help you. We also encourage you to spend a little bit of time on our website, search up your medical condition, specifically search your company, and learn about all the cases that have come up against your company. Look at reviews from other claimants about what they think of their experiences with the company, and you can search by your medical condition. We have a lot of different options and information that are hopefully related to what you're going through, because we want you to be educated as a claimant about this long-term disability insurance process. Now, if you are an insurance claims adjuster, obviously you're familiar with how claims are handled and the internal structure of what goes on behind the scenes. But if you're not in the disability insurance world, it might be slightly different to what you're used to. But obviously you know enough that you probably need the support of a lawyer to help you through this process no matter what stage you're at. So we look forward to the opportunity to speak with you, and we'll be here should you need us in the future. Thank you.